I'm Rosemary Cundiff, and I work for the State Archives. And as of a little over a year ago, I became the Government Records Ombudsman, and part of my role is to assist people who are responding to GRAMA requests. So anytime you get a GRAMA request and you have questions and need help, you can give me a call and I'll see what I can do to help. But to get into our training today, we're going to be talking about GRAMA, and the first section of GRAMA talks about legislative intent. And I think it's a good idea to understand the legislative intent, because if you understand what the legislature had in mind and why they created this legislation, that helps you to know how to think about things. So in the first section, the legislature recognizes two constitutional rights. It says the right of the public to access information about the government. I'm not quoting this directly, but the right of the public to access information about government, the right of transparency on the one side, and then on the other side, the rights of individuals to have information about them remain private. And then in the second point, the legislative intent recognizes that there is a public interest in restricting some information. So we have transparency on one side, and then the rights of individuals to have information about them remain private, and also the right of the government to restrict information that's in the public interest to be restricted on the other side. And so the law is there to provide guidance as to which is which and how you should interpret that. So in the sections underneath, let's see, there's a number of points underneath that in the law, and they are to promote the public's right to easy and reasonable access to unrestricted public records. And if you have a handout, this is in the handout, but it's not on the slide. So we will be getting more handouts in just a minute, and you can follow along. But so the intent is to provide easy access to unrestricted information, to specify the conditions under which the public interest in allowing restrictions on access outweighs the public's interest. The public interest in restriction outweighs the public interest in access, and to provide guidelines for both disclosure and restrictions to access, and a basis for equitable weighing of those interests. And then it says that we should favor public access whenever the scales are equal and it's not possible to tell which interest outweighs the other, then we should favor public access. So in the next section of GRAMA 103, that is the definitions section, and we just picked out a couple of definitions that are really important. And number 22, a record, the definition of a record, because everything in GRAMA is about government records. So if we are to interpret this law, we have to know what a government record is. So a record means a book, letter, document, paper, map, plan, photograph, film, card, tape recording, electronic data, or other documentary material, regardless of physical form or characteristics, that is prepared, owned, received, or retained by a governmental entity or political subdivision, and where all of the information in the original is reproducible by photocopy or other mechanical or electronic means. So there's three characteristics there. In the first place, it has to be some format, some format that contains information. And second, the information has to be prepared, owned, received, or retained by government, by a governmental entity. And it has to be reproducible. So there are things that you might prepare or things that you might own that you didn't receive, or at any rate, it's prepared, owned, received, or retained, and it wouldn't have to be all of those, but only one of those. And finally, the information has to be reproducible, so that eliminates phone calls that aren't recorded, or anything that you can't reproduce is not a record. So the law goes on to say what a record does not mean. And the points on this slide are a few of the most common ones, but there's a lot more identified that are not records. But a record is not a personal note or personal communication prepared or received by a government employee in their personal capacity. So if there's email in your email box or other things that you have at work that are not about work, that are about your personal business, those things are not records. And another example of something that's not a record is a temporary draft or similar material that's prepared for the originator's personal use or prepared by the originator for someone that they're working for. And so I think the key word in that phrase is temporary. It's something that like you are using to create something more final. Like, for example, when I am taking phone calls, while I'm talking on the phone, I write down the name of the person and their phone number and some notes about what our conversation was about. And then after the phone call is over, I have a log that I enter that information into. So the notes are a temporary draft that just goes by the wayside as I create a more permanent record. So temporary drafts are not records, and material that is owned by an individual in their individual or private capacity is not a record. So you can probably think of examples, but also a daily calendar or other personal note that's same thing. A personal calendar. Your calendar is not a record. So, and I invite any of you to raise your hand and ask questions or make comments as we go along, because this is, a lot of straight out of the law, but yes.
Question. So, what about like if I'm working on the town budget and I'm not done, would that be an official record, or just classified as a draft, so it would be a record, and like the council meeting minutes?
Oh, you're working on the draft of the council meeting minutes?
Well, yeah, during council meeting I type really fast.
Right.
And then I go home or in the evening, whatever, I type them up so that they're official.
Uh-huh.
And they approve them, so the draft would not be a record.
Okay, so the notes, you're taking the notes you made at the council meeting and creating a draft?
A permanent record. Well, the draft would be what I typed at council meeting,
Okay.
so that would not be an official record?
There's information about that in the Open and Public Meetings Act, and it talks about, I can't remember the
When it's basically to the
You-
Then that's when it becomes a public record.
Right. So,
Even though they're not approved, but if somebody requests it, then you write over it, that
mhm.
draft, not approved yet, whatever.
Right. So before the minutes are approved, there has to be a draft available for the public. And that draft has to be marked, this is a draft,
Well,
or something like that.
it's not a public record until you've got it essentially ready. Because I'm telling you, people call the day after the meeting and they want a copy of those, and they're not getting that kind of crappy stuff that we've initially just taken down notes on.
Right. Those temporary notes that you took during the meeting.
Hey, I've seen your stuff. It's just like all the rest of our stuff.
Okay, that was a good question and a good example. So does that make sense, though?
Yeah, so the same thing would apply like when I'm working on our town budget, because I'm not done yet, I'm still moving figures around, but people still want to see it, and it's like,
Right.
it's not done, it's not gonna mean anything,
Right.
so, okay.
So, right, temporary drafts are not records.
How about junk mail?
Junk mail is on the list and it's not a record. And other things on the list are anything that's copyrighted material or library material, and those things are not records either. Also, for law enforcement, the phone numbers for their cell phones are not records. That is interesting. Okay. Another definition that's important is classify. Classify and the derivative forms means determining whether a record series, a record, or information within the record is public, private, controlled, protected, or exempt from disclosure. So classifying basically means deciding whether or not to release a record or to release information within a record. And then number 7, designation. To designate, and all the derivative forms of designate means indicating based on your familiarity with a record series, a set of records, or a review of a sample of the records in a record series, what you might classify that record series. So does everyone understand what a record series means? Because that's another definition that we're assuming you know. But a record series is a set of records that serves a function. Like the council minutes is a record series, and correspondence, or, So if you're going to designate a classification, you're going to think about that set of records as a whole and decide how you would classify those and designate a classification. However, when you get a request and you look more specifically and closely at the records that are being requested at that time, you would classify. So does that make sense, the difference between designate and classify? We're going to designate a classification to a group, but then classify something specific. Okay, another definition that I want to talk about that I don't have a slide for is governmental entity. So a governmental entity is, it means executive, I won't read this, but basically it means all of the departments, agencies of state government, including the courts, the legislature, and the executive, all of those. And then it also means any political subdivision, basically any office, board, bureau, committee, department, advisory board, or commission that is either funded or established by the government. So anything that's funded or established by the government to carry out the public's business is under the definition of governmental entity, and they all are responsible to abide by GRAMA. They're all subject to GRAMA. So an example of something that's not a governmental entity would be political parties or the PTA or, those kinds of things. So, let's see. Another definition that I don't have a slide for is a person. And in GRAMA, a person means an individual. It's in your handout, an individual, a nonprofit or profit corporation, a partnership, a sole proprietorship, or any other type of business organization. So person doesn't mean, individual means a human being, but person can mean any entity like a corporation or LLC or what have you. Okay. So, and then on 21, a public record means a record that is not private, controlled, protected, not exempt from disclosure. So, okay. So, those are some highlights from the definitions section of GRAMA. And thereafter, there is 106, which discusses records of security measures. So, and it says that the records of a governmental entity or political subdivision regarding security measures designed for protection of individuals or property, public or private, are not subject to this chapter. These records include security plans, security codes and combinations and passwords, passes and keys, security procedures, and public works designs to the extent that they give information relating to ongoing security measures of a public entity. So all of those things, yes.
Just saying that it's a little bit confusing,
Mm-hmm.
because when our councils go into closed door, there's a certain number of items that they can only go into closed door for. One of them happens to be the deployment of security devices.
Mm-hmm.
That is considered a public record when it's the closed door record of that. And so that's a little bit confusing because it's a little bit different than the list.
Uh-huh.
So those closed door minutes that discuss it do fall under GRAMA and they're considered protected.
Right.
But I guess all these other things don't.
Right. So this is, computer passwords and keys and things like that are obvious, but the State Records Committee heard something about the surveillance cameras, the tapes in the surveillance cameras that show who's coming and going, and they ruled that those are security measures as well. So, let's see. At any rate, it doesn't say these things are not records, but these things are not subject to GRAMA. They're not subject to disclosure. Okay. And then, this was just added in 2012, and that's why you're all here today. But each records officer of a governmental entity or political subdivision shall, on an annual basis, successfully complete online training and obtain certification from state archives in accordance with the Public Records Management Act. So you're all here today to get certified, and you can take the test here today, but you also can take it online anytime during the year. And are there any comments or questions about that?
So what's, in the handout, what's the chief administrative officer?
Okay.
There's one, the records officer, and then there's the chief administrative officer.
Right. So the chief administrative officer is, it might be different for different agencies, but it's the person with highest authority. So it's probably the mayor or the city manager. It's whoever.
That's what I was wondering, if that was like the same definition the way I took, or if the chief administrative officer was different when I came to GRAMA.
No. So in the Public Records Management Act, it lists the responsibilities of a chief administrative officer. And one of those is to appoint a records officer or records officers to do all the things they can think of with records. And so we've been careful at the archives to go back to the chief administrative officer and ask them who the records officers are. So if you click on the link to take the test, then an email goes to the chief administrative officer asking them to validate that you are the person appointed to be the records officer. So, okay. That is the end of the first module or the first section about the basic general provisions. So the next section of GRAMA is 201, and that is access to records. So we skipped over to 204 before 201, and so starting with 204, it talks about requests for records, time limits, response, and extraordinary circumstances. So the first point is that a person making a request for a record shall furnish the governmental entity with a written request containing the person's name, mailing address, daytime phone number if available, and a description of the record requested that identifies the record with reasonable specificity. So that's 4 things that a GRAMA request must contain: name, address, phone number, what do they want. And reasonable specificity means they have to tell you what they want in a way that you can understand it. It can't be so broad or ambiguous that you're guessing what it is they want. And the other requirement is that it has to be in writing. So there's forms on the archives website, and many of your municipalities have forms that people can fill out for GRAMA requests. But you could, an email or anything else, as long as it's in writing, could function just as well if you don't have a policy prohibiting that. So
did you just say that any records request you have to have the form filled out? Is that what you
didn't say that.
Oh, okay. All right.
Okay.
You don't.
Later on, we'll see that governmental entities can pass ordinances that are applicable within your city. And you could pass an ordinance saying you must use this form, but if you haven't done that, then anything that's in writing would be acceptable. Does that make sense? Okay. Okay. So after receiving a request for a record, the governmental entity shall, and then there's 4 different possible ways to respond. And it doesn't say that right here, but just, you all know how many days do you have to respond? 10 business days, okay? Unless they ask for an expedited response and you honor that, and then it's 5. But for our purposes here, the ways that you can respond are, first, you can.
You have to have a legitimate reason for an expedited request, though. You don't have to do it just because they asked for one.
That's right, you don't. And the reason for the expedited response would be because responding within 5 days is in the public interest. And it has to be that. So,
Which the newspaper always claims.
that's right. And the section in the law says that anyone who is requesting a record for the purpose of writing a report for publication is acting in the public interest. And that is the basis for their claim that their requests are in the public interest. That's backed up in the law. So
They're all heroes.
we want to support the press, don't we? Yes. What? Okay. So anyway, back to the possible responses. In the first place, you can approve the request and provide a copy of the record. So actually, when you think about it, when you get a request, there's a series of questions you should ask yourself first. Is it a record, right? And if it is a record, do I have it? And if it's something that you don't have, then the third possible response here is notify the requester that it does not maintain the record requested and provide, if known, the name and address of the governmental entity that does maintain the record. So if you don't have it, then a referral is a response. So yes.
So if you have a copy of it or a forward email of not the original, can you say, I'm not the keeper of that, even though you do have a record of it, you can send it back to somebody else?
That's a really good question. And that gets into record sharing. And so can we defer to talk about that when we get to record sharing? No problem. But yes, if you are maintaining the record, then possibly you want to respond, but you would need to work that out with the other governmental entity that may have created the record. So I just want to emphasize this, notify the requester that you don't maintain the record is a separate response from denying access. So the second one is you can deny access in accordance with the procedures. So what happens if you say, I don't have this record, therefore I deny it, and you can appeal? It gets kind of messy that way. So let's take a minute. We now have the training materials. Do we have? Raise your hand if you don't have these. So the fourth possible response is to notify the requester that because of one of the extraordinary circumstances listed, you cannot immediately deny or approve access to the record. And then along with that, you would let them know what the extraordinary circumstance is and what they can expect. So, if a governmental entity fails to provide the requested records or issue a denial within the specified time period, that failure is considered the equivalent of a determination denying access to the record. So that means if you get a GRAMA request and you put it on the bottom of your pile of whatever you're doing and don't respond at all, then you have denied access. Okay, there's in the handout, you all have this now. It's on page 15. Will you turn to page 15? So this is the list of extraordinary circumstances that is listed in GRAMA, and they're listed in 204, section 5, and then the responses to those is in section 6. So it has to be one of these extraordinary circumstances, and they are another governmental entity is using the record. So if another governmental entity has the record and you need to get it back, then the remedy for that is that you have 5 extra days. The next one is a governmental entity is using the record as part of an audit. And then you would tell the requester that they have to wait until the audit is finished. Then there are 3 that are similar, but they are that the request is for a voluminous amount of records, and that it will take more than 10 days to compile that, or you have voluminous number of requests, or it requires you to review a large number of records to find what's responsive to their request. And so in all of those extraordinary circumstances, the remedy is that you should provide what you can and then give them an idea of when you will be able to complete the request. Let them know that it's going to take 2 weeks or 3 weeks or however long. And then another extraordinary circumstance is if releasing the record involves legal issues and you need to consult with an attorney about this before you make a decision. So if you need to do that, then you get 5 additional days. And 15, 16. The next, let's see, I have my pages mixed up. But six, 15. Okay, here we go. The other 2 are segregating information that the requester is entitled to, inspect from information that they're not entitled to inspect, takes some extensive editing, and in that case you get 15 business days. And if segregating the information requires computer programming, then you would just let them know how soon they can reasonably expect to get the records. So just to review, there are 4 ways to respond: provide the record, deny the record, give them a referral, or let them know that because of one of these 8 extraordinary circumstances, you need more time. Okay?
Rosemary,
Yes.
What about requiring them to bring food?
Yes, you can do that too.
Yeah, because there's nothing worse than having somebody make a huge request for you, to spend all this money, and then 6 months later, they still haven't picked it up.
That's right. So, and we'll get to that, but if the request, if it's going to cost more than $50, or if they haven't paid for records requests in the past, you can require prepayment before you respond, or provide records rather. Okay. Now, a couple of other things before we move on from section 204 about requests is calculating time. And this isn't in GRAMA, but calculating time is if it is 11 days or if it's fewer than 11 days, then time is calculated as business days. But if it's greater than 11 days, then time is calculated as calendar days. So, okay. So if it's 10 days to respond, that's 10 business days. But because 30 days to appeal is greater than 11, then that's calendar days. So that's how you calculate that. And let's see. In answer to the question back there, if more than one governmental entity has the same record, then you would need to decide how to handle that and respond or refer. Okay, so let's turn back to the beginning of the section on access to 201. So the first point in section 201 is every person has the right to inspect a public record free of charge and the right to take a copy of a public record during normal working hours, subject to paying the fees. So every person means anybody, regardless of the reason they're asking for the record, regardless of who they are. And that's a public record. And then point 2 says, I don't know if I don't have it on here, but point 2 says that a record is public unless otherwise expressly provided by statute. So that means that for every record, unless there's a specific reason in the law to restrict access, you have to say that it's a public record. So, and then number 3 says the following records are not public: a record that is private, controlled, or protected, and a record to which access is restricted pursuant to a court rule, another state statute, federal regulation, and so on. And then only the records specified in GRAMA are classified as private, controlled, or protected. So when we talked about the weighing of access, so there are some things that are going to be withheld because it's in the interest of a person. The information is private. So records that are classified as private are restricted because they contain information about a person that shouldn't be released. And also records that are controlled are the same. They contain information about a person that shouldn't be released. But information about protected records are restricted because it's in the public interest to restrict those records. It's in the public interest. They're usually, although sometimes they could be, but it's usually not about people, but about like an example is tests and test question answers, or the closed sessions of the meetings. Those are protected because it's in the public interest. So then the second section of this is that many records are restricted because there is some other law other than GRAMA. It's a federal law. It's HIPAA, or it's FERPA for school districts, or there's lots of other laws. But any time that there is another law that restricts access to records, that other law will specify exactly how access should be provided and exactly who should get access to that record, and you would follow that law, and that would supersede GRAMA. Are there any comments or questions about that? So I've already, some more points I want to bring up before, actually let's turn to number 8. And this, if you have a copy of GRAMA, turn to this 2018, because the slide doesn't list everything. It only lists a few things. But in response to a request, a governmental entity is not required. And this section of the law was added a few years ago to try to help government, to protect government from abuse, basically. But in response to a request, the governmental entity is not required to create a record, not required to compile, format, manipulate, package, summarize, or tailor information, not required to answer a request if it unreasonably duplicates a request that you have already provided. So if a requester asks for something this week and they ask for the same thing next week, you don't have to do it again. You don't have to fill a request if the request is for something that is in a publication or otherwise available. For example, if it's available online, then you would direct them to that website or wherever they can find that record or information, and you don't have to provide it in response to the request. And However,
I have
Af-
a question on that one.
yes,
What if the website that they go to requires them to pay a fee for
That-
this information, such as the state construction registry?
Mhm. So would it, that's a good question.
I mean, it's available to them.
Right. It doesn't say anything about that here. It just says that if it's available, you can direct them to where it's available. Okay. But after having said all that, you're not required to create a record or compile or format or all these things. Then it says that you may do so. You can choose to do any of those things, as long as it doesn't interfere with your work and your business, and as long as the requester is willing to pay for it, to pay for that request, the time you took to create the record or to compile or to do whatever needs to be done to accommodate that request. So, and then number 12, turning down to number 12, talks about when you should provide an electronic copy in lieu of paper. So, if the requester asks for an electronic copy, then you should do it if they state that they want an electronic copy, if you maintain it already in that format, and if you can provide it without also providing information that is restricted. So, and then number 11, just above that, says that a governmental entity may not use physical form, electronic or otherwise, to unreasonably hinder access. So you cannot deny access to a record because it's in a format that's not accessible. Okay? Let's see. Oh, I've got a slide on that. Okay. Then, before releasing access to private, protected, and controlled records, the governmental entity should obtain evidence that the requester is who they say they are. You should make sure that if you're releasing a private record to the subject of the record, that you know that they are the person that they claim to be. So, let's see, is there anything else in that section I want to bring up? Okay, so let's move on to section 203, which is about fees. Okay. A governmental entity may charge a reasonable fee. There we go. May charge a reasonable fee to cover the governmental entity's actual cost of providing a record. And this fee should be approved by the governmental entity's executive officer. So, number 2 lists the things that you can charge for. The cost of staff time for compiling, formatting, manipulating, packaging, summarizing, or tailoring records, either into an organization or a media to meet the requester's needs. The cost of staff time for search and retrieval, other direct administrative costs. And in the case that fees for a record requires computer programming, you can charge for that. And then it goes on to say what you can't charge for. A governmental entity may not charge a fee for reviewing a record to determine whether it's subject to disclosure, and then you cannot charge for inspecting a record. So, does that all make sense?
Rosemary, I have
Ye-
a question.
Yes.
We have some really, really old cemetery records. When people come in like and say they want to go through the cemetery records, if we could provide that record for them without them having to go through and copy out of our old files, can we do that?
So-
When they put in a request to look at or go through my old cemetery files, I'm really protective of those because they're so fragile.
Right, and so you have it in a different format?
Is that okay to do that?
Oh, absolutely,
Okay.
absolutely. Okay. And then, this says a person who believes that there has, the saying that if you deny a fee waiver, then they can appeal that in the same way that they appeal a records denial. So, there's a couple of other points on fees. Let's see. Number 3 talks about how fees are established. So in state government, fees are established by the legislature, but for local governments, fees and fee schedules should be established by your council, your administrative body. So they should determine how much you should charge for copies and different things. And then number 4 says that a governmental entity may fulfill a records request without charge and is encouraged to do so when releasing the record, and there's 3 things here, when releasing the record primarily benefits the public rather than an individual, when the individual requesting the record is the subject of the record, and when the requester's legal rights are directly implicated and the information in the record, okay, let me back up again. The requester's legal rights are directly implicated by the information in the record, and the requester is impecunious, meaning they're a prisoner or they don't have any money to pay. So, during the last legislative session, the legislature considered changing may to shall, but that didn't pass, so it says may. You may waive the fee. And over the years, the Records Committee has seen this as permissive and not a requirement. Yes?
So are there any guidelines on how to determine if a person is impecunious?
That's a good question. They can tell you I have no money. In real life, most people who are making that claim are prisoners, and they make a lot of GRAMA requests. But it could be.
Owned a house,
Mm-hmm.
that, I mean, it wouldn't be their total, I mean, if they got a house, they got some assets, right? Or
Yeah.
maybe if the judge, if it was related to a court case, maybe if the judge said, if the court determined they were, then that would be good enough?
I would think so. I would think so. Okay. Then number 8 says that, and we already mentioned this, but you can require prepayment if they haven't paid for records requests in the past and if the fee is going to be more than $50. So it's really a good idea if it's going to take some time and work to compile something and you're going to charge a fee, to let them know in advance exactly what to expect. Because, you know, if you go to a lot of work to prepare something and it's $400 or $500 and they didn't expect that and they come back and say, never mind, you're just out. So even though it's not required that you let them know up front, it's really a good idea. Okay. So if we are going to provide the record, then we might be charging fees, but the second possible response is to deny the record. And so if a governmental entity denies the request in whole or in part, it shall provide a notice of denial to the requester, either in person or by sending a notice to the requester's address. And then this notice of denial shall contain the following information, okay? So you're going to go back and provide a description of the record or portions of the record that you're denying access to, and a citation in the law. Because remember, all records are public unless there's a reason in law to restrict access. So you're going to provide that citation in the law upon which you've based restricting access. And that could be another law other than GRAMA. It could be, HIPAA or whatever else. But in addition to this citation, then you should provide a statement that they have the right to appeal your denial to the Chief Administrative Officer, and let them know that that time limit, which is 30 days, and let them know that they can, who the Chief Administrative Officer is, and their contact information, all the details that they need to appeal. So, what if you are providing some records or providing a record and redacting part of it, then you need to do both. Provide records and give a notice of denial for the ones you're not providing, because many requests include more than just one record. And so you can, make the combinations that way. So, let's see. All right. Okay, the other thing about denials is, unless otherwise required by a court or agency of competent jurisdiction, a governmental entity may not destroy or give up custody of any record to which access was denied until the period for appeal has expired and the end of the appeals process, including judicial appeal. So if someone comes in and requests a record that has already met its retention and you could have destroyed it last week, now that it's requested, you cannot destroy it until the whole appeal, the time for appeals, everything is passed. Okay? So there's another, I want you to go back to the handout to who has access to. Let me see which page this is on. There's a table in there about who has access to private records, controlled records, and protected records. I just want to call that to your attention. So, this is outlined in section 202 and 203 and also in various places, but we put this table together so that you can see who you should provide access to private, controlled, and protected records. And those are the three classifications listed in GRAMA. But basically, private records are accessible to the subject of the record, the person the record's about, and to their a parent or a guardian or someone with power of attorney, things like that. Access can also be granted, private records can be shared, okay, with other governmental entities, or if there's a court order or legislative subpoena, or if there's bona fide research. And there are citations in the law, but basically think about private records as being accessible to the subject, the person the record's about, and that group of people who has authority for them. Then controlled records are a narrow class of records that are psychiatric and they are available not to the person the record's about, but only to healthcare providers, to a psychiatrist or a social worker or a psychologist. And also shows also that these can be shared or used by a bona fide researcher or in response to a court order. Okay. And then protected records, access to protected records can be provided to the person who provided the record or an individual who has power of attorney for all of the, and a notarized release for all of the interested parties who were protected by the classification. And then this also has the possibility of sharing records and access provided in response to a court order or legislative subpoena. So,
Can you repeat that again?
okay.
On the protected, sorry.
On the protected, you can provide access to the person who provided the record in the first place,
Okay.
or someone who has a notarized release from the people whose interests are being protected, or a court order, legislative subpoena, or a bona fide researcher. I don't know. Anyway, so can refer to that graph for that. Okay. Do you have any questions about providing access about this section of the law? 3, yes.
Did you say a controlled record could be released to another government agency or not?
Yes. But that's under record sharing and okay.
Okay, so the bona fide researcher, they can get a protected record, but they can't get a controlled record.
I think they can, does it say that on the chart? I think they can get, that a bona fide researcher can get any of those.
Any of those records, okay.
But, okay. Let's see. There's a section 206 record sharing. Let's do. If you have the law or the handout, turn to 206 about record sharing. And the law is not as straightforward here as I would like it to be, but I went through all these sections and kind of put them together. And so you will share records. I'm sorry that I don't have a slide for this, but if you look at the handouts, you will share records with another governmental entity if there is a law that requires you to share those records, or if sharing the records is a requirement of a federal or state grant or a government program. There is something you're participating in that requires sharing records. Okay? Other than that, you will share records with an archives or repository that is using the records for maintaining them or preserving them or destroying them. Or you will share records with an auditor that is using them for an audit. Or you will share records with another entity that is using the records for enforcement or investigation or those things that have to do with law enforcement. Or you will share records with the legislature or anyone in the legislature who needs those records as part of the legislative process. Okay? So if the sharing doesn't fall in any of those, then you would need a written agreement, and the agreement would have to say that the person requesting the record needs those records that it's in the public interest, that they need the records to fulfill a purpose similar to the purpose that the records were created for, and that they will abide by the same classification as the originator. Okay? So if we're in the case where we're sharing records, it's a good idea to make some kind of, what am I looking for? An agreement or other arrangements so that you know exactly who's going to provide access and what the classification is. So, because the law on providing access says anyone who retains the record could provide access. So, if you're sharing records, then you have to decide who's going to do it and how that's going to happen. Are there any questions about sharing records? Okay, so you can share records with, also share records with a contractor or private provider. So a contractor is either a nonprofit that government is funding, or it is any person. Remember the definition of person. Anyone who is doing work for government, that government is paying to do work for government. That's a contractor. A private provider is someone that government hires to do work for the public. So if you share records with a private provider or a contractor, then you will need a written agreement that they agree not to disclose those records to anyone, that they need the records for the contract, and that, they're not going to use them for any commercial purpose. So that's kind of a summary of this whole section on record sharing. Are there any questions about that? So, okay. Yes?
If we share a record, then the receiving agency cannot change the rules, can they?
They cannot. The recipient agency must abide by the same classification, and you must notify them what the classification is. So, I think you could notify them as it pertains to a set of records as opposed to every record individually, but you can work that out. Okay, and then 207 talks about subpoenas. A subpoena is an important thing to remember about subpoenas is that a subpoena is not a GRAMA request. There's discovery, a whole process, that judicial process for obtaining records, and a subpoena is part of that process. And government records access request is a different process. That's a process where records are provided to the public. So what you need to know about a subpoena is that it's not a GRAMA request, and that you should let your attorney handle that, or just give it to an attorney that represents you and let them deal with it. Any questions? Okay. Now let's go on to the classifications. So this is section 301. So, the first section, 301, is public records. And these are divided into two lists. The first list is records that are public except to the extent that they contain information expressly permitted to be treated confidentially under the provisions of the other sections. Okay. So, this is saying that everything on this list is a public record. But having said that, there might be elements within the record that would not be public. So an example would be, let me ask you, is there ever a time when there's private personal information within the minutes? No? Maybe not, but it's possible that there could be certain information within these records that would be private or protected, and that you would want to redact that or remove that before you disclose the record. Okay, so going down that list, the number A is laws. That's obvious. But number B is the name, gender, gross compensation, job title, job description, business address, business email address, business phone number. And in the line above, that only has to be one business address and one business phone number, except for not for undercover law enforcement personnel or investigative personnel. So the idea here is that the public has a right to know who works for government, what their qualifications are, and how much they're being compensated as a whole. Number C is information contained in or compiled from a transcript, minutes, or report of the open portions of a meeting of a governmental entity, according to the Open and Public Meetings Act. So any of those minutes or transcripts or recordings or things that are part of the open public meeting are public records. And then number G, records that are maintained by county recorders, clerks, treasurers, surveyors, zoning commissions, and so on. But basically, this is all of the information about property ownership, whether it's easements or whatever, information that defines who owns property. And then, let's see. Number J, documentation of the compensation that a governmental entity pays for a contractor or a private provider. And number I, data on individuals that would otherwise be private under this chapter if the individual who is the subject of the record has given the governmental entity written permission. So that means anytime you have some private record and the person the record's about gives you written permission, and I would probably say notarized written permission to release that record, then it becomes a public record. Okay. And let's see, summary data, which is like statistical information that you have compiled from protected or private records that doesn't reveal any protected or private information. Like, for example, how many traffic accidents were there? You can give a statistical number without revealing anyone who was involved. And then voter registration records. So those are not all of the records on that list of public records. And at the end it says that this is not an exhaustive list. But do you have any questions about records that are public? So After this list of records that are public, it goes on to a list of records that are normally public. So that's point number 3. The following records are normally public, but to the extent that a record is expressly exempt from disclosure by under another statute. So the records on this list are going to be normally public, but in some instances, there would be cases where they would be private or protected in whole, not just something within it, but the whole record could be classified as private or protected or something else. So some of the things on this list are administrative staff manuals and records documenting a contractor or private provider's compliance with the terms of a contract. Records documenting the services provided by a contractor or private provider. And contracts. Let's see. Chronological logs for law enforcement. And then drafts. So we talked about drafts, temporary drafts being not records. But here we see that a draft that has not been finalized but has been relied upon to make a decision or to carry out a policy is a public record, normally public record. And also, number K, drafts that were not finalized. Wait, that's K that I just said, but J is drafts that were circulated to anyone other than the governmental entity, the political subdivision, a federal agency, or a contractor or private provider. So basically, if you use a draft to make a decision, or if you circulate the draft outside of your governmental entity and the people that are working directly with you, then that draft becomes a public record. Okay. And then number O is records that disclose information relating to formal charges or disciplinary action against a past or present governmental entity. If the disciplinary action has been completed and the time periods for administrative appeal have expired, and the charges on which the disciplinary action were based were sustained. So if there are, do you deal with internal investigations? If there is an internal investigation, then it only becomes public after the whole process is complete and time limits for appeals have passed and the charges were sustained. Then it becomes public. And then also on this list, final audit reports, occupational and professional licenses, and business licenses. Okay. And this list of the list of records in this section is not exhaustive and should not be used to limit access to records. So if it's not on this list, that doesn't mean it's not public. Okay.
Question for you.
Yes.
Did you say that employee performance evaluations are public or they are not?
They are not. So what is public is the qualifications, education qualifications, why someone is qualified to work. So the next section is private records, and the following records are private. The first, this also is a two-tiered list. So there's the first list of things that are private, and then the list of things that are private if properly classified. But the first one on this list is records concerning an individual's eligibility for unemployment insurance benefits or social services, welfare benefits, or determining any of those benefit levels. So information about benefits is private. And then number B, records containing data on individuals, describing their medical history, diagnosis, treatment, condition, evaluation, and similar medical data. So that's not a medical record per se. Oh, yes. Okay. That's not a medical record per se, but any record that has any medical information within it. So like a police report or something that talks about someone's medical condition, that information would need to be private. And then records of a publicly yes. And everything I'm going through now is private. Period. Private. No exceptions. So records of a publicly funded library that identify a patron. That's interesting, but what you check out of the library is not anyone else's, no one else has a right to know. And then number G is employment records concerning a current or former employee of or an applicant for employment that disclose the individual's home address, home phone number, social security number, insurance coverage, marital status, payroll deductions. So we saw that gross compensation was public, but their payroll deductions or exactly all the details of how they're being paid is private. Okay. Number K is any records that contain information about individuals that's voluntarily provided and that goes into an electronic database that is designed to administer government programs. So that information that you collect and put in a database is private. Okay, is there something else? Okay, I'm going to stop there. Those records are private, and then there's another list that's private if properly classified. So this section is more discretionary. You could think of it as usually private, but the first one on the list is records concerning current or former employee of or applicant for employment of a governmental entity, including performance evaluations. We had a question about that. Performance evaluations and personal status information such as race, religion, disabilities, etc. Okay, and that exception is to the gross compensation. And then number B is records that describe an individual's finances. So records, let's see, other ones I want to point out. Number D is particularly important. Records containing data on individuals, the disclosure of which constitutes a clearly unwarranted invasion of personal privacy. So this is saying that they haven't identified or listed every record that could be private, and so you can use this this code if it's a clearly unwarranted invasion of personal privacy and it's not specifically listed somewhere else. So I just want to point out that it says clearly unwarranted invasion of personal privacy, and that's a higher standard than just maybe this is private. It needs to be clearly unwarranted. Okay, the list of records that are normally public is actually pretty short, but after that, Section 304 talks about controlled records. And a record is controlled if the record contains medical, psychiatric, or psychological data about an individual, and the governmental entity reasonably believes that releasing the information in the record to the subject of the record would be detrimental to the subject's mental health or to the safety of an individual, anyone, or that releasing the information would constitute a violation of normal professional practice and medical ethics, and the governmental entity has properly classified the record. So if you have psychiatric evaluations or psychiatric information that you feel would be detrimental for the person the record's about, or if it is not in accordance with professional practice, which it's not for psychologists and psychiatrists to give you their notes and records about their patients, then those are controlled. That's a very limited classification. So then we move on to protected records. And protected records are restricted because it's in the public interest. And the first one is trade secrets. So trade secrets are protected. And then commercial and financial, there's several of those variations of commercial and financial information that would interfere with, or number 3 is that would potentially lead to financial speculations. And number 6, records, the disclosure of which would impair government procurement proceedings. So this is about bidding. So if the government is taking bids for something, then all the information that relates to those bids is protected until the whole bidding process is complete and all of the contracts are signed. And then it may still be protected if releasing that information could reveal a trade secret or give someone a competitive advantage. So that's, I'm looking for one in here. Number 5, which isn't on the slide, but it's test questions and answers. That means that all the tests we passed out today are protected records, right? So before you leave the room, you have to give the test back. Okay? We'll remind you. And then these protected records are very specific, and so until the legislature specifies a specific record or situation where something is protected, then it's an exhaustive list. And I just like to say that this list grows. Every time the legislature meets, they add more. So a few years ago, there were 50. Now there's 65. And after May, there will most likely be something else that someone will push through, and there will be more protected records. But in the last legislative session, number 7 was added, which is information that's submitted to a government in response to a request for information. So it's not just the bids that are protected, but also requests for information in preparation for a bid. So, the state requested information for relocating the state prison, and they're not having any bids or anything yet, but they want to protect the people who provided ideas. So requests for information are protected. And then number 10, which is on the slide, is records created or maintained for civil, criminal, or administrative enforcement purposes, or audit purposes, or for discipline, licensing, certification, or registration purposes, if releasing the record could reasonably interfere with any of those processes. So that means if releasing the record could interfere with an investigation, or if it interferes with an audit, or number C, if it could create a danger of depriving a person of the right to a fair trial or impartial hearing. And number D, reasonably expected to disclose the identity of a source who is not generally known outside of government. And reasonably expected to disclose investigative or audit techniques. So that number 10 protects a lot of government processes like investigations and audits and certifications and things like that. So this is something that's very subjective. So when you get a request, you would have to look at the record and think about what's going on in your agency to make a determination about whether releasing that record would interfere with something. So that's part of what makes it.
Can you share protected records?
Yes. So under all those conditions that I mentioned earlier, if it's certain government entities or if they are using the record for a purpose similar to what you're using it for, or I'm repeating myself, but yes. Okay. Number 11 and 12 are records that would jeopardize the life or safety of an individual or that would jeopardize the security of government property. And then number 17, which is on the slide, is records that are subject to attorney-client privilege. And in order to qualify as attorney-client privilege, it has to be an attorney that you have retained for a specific issue, and it has to be communication about legal advice about the issue that you've retained the attorney for. It can't just be any communication with any attorney. Okay? And number 18 is records prepared by an attorney, consultant, surety, indemnitor, insurer, this whole list, in anticipation of litigation or an administrative proceeding, a judicial proceeding. An administrative proceeding is some proceeding like the State Records Committee or some like a judicial proceeding, in that there's going to be some kind of hearing or decision at the end of the process. See, some other ones I wanted to point out are number 32, which is not on the slide, but it is the transcripts, minutes, reports of the closed session of a public meeting. So anything that is involved with the closed session of a public meeting is protected. And then number 51, which is on the slide, is the name, let's see, not the name, I said that wrong, but an individual's home address, home phone number, and personal mobile phone number if the individual is required to provide the information in order to comply with a law, ordinance, rule, or order of a governmental entity, and the subject has a reasonable expectation that this information will be kept confidential. So that protects. This is designed to prevent requests that will be used for solicitation purposes. So if someone is required to provide their home address and phone number, then it's protected.
Question?
Yes?
So if we print up a little town directory, it's protected then, right? If somebody wants to buy it and say sell cable TV, they would just say it's protected, you can't have it?
Yes, if the people whose addresses and phone numbers were required to provide that to you, then.
But if they did it voluntarily?
If they did it I'll give you an example. The State Records Committee heard a hearing which was of the Public Service Commission that investigates complaints about utilities. So the requester wanted information about who complained, what was their address and their issue and their contact information. And the committee decided that because they weren't required to complain, the information was not protected. But I mean, I guess how I would be interested in your feedback about that. Because it says if they're required to provide it in order to comply with a law or ordinance or something.
There wasn't any, it was just so everybody in the town could call each other.
Mm-hmm.
So they weren't required.
Okay, I'm going to go ahead and say that it's your responsibility to classify your own records and decide, but if it were me, I would protect it. Okay. So, and this is the next point. Number 307 says that it is the duty of, basically says that it is the duty of every governmental entity to classify their own records, to evaluate every record series that you create and to designate classifications and to notify the state archives. And number 2 says that you can classify a record at any time, but you're not required to classify it until it's requested. So there's no requirement for you to classify anything until that record is requested. And then number 3 says that you can redesignate a record series or reclassify a record at any time. Okay? So, Section 308 deals with segregation of records. So, notwithstanding any other provision in this chapter, if a governmental entity receives a request for access to a record that contains both information the requester is entitled to inspect and information the requester is not entitled to inspect, then the agency is to show or provide access to the information that the requester is entitled to, and to deny access to the information the requester is not entitled to. So that could mean that you're separating this report from that report. It could mean that you're separating one page from another, and it also could mean that you are segregating information within a single page. So you would, use software or a magic black marker or something to segregate. They're entitled to this and not entitled to that. So if you have then segregated certain information out of a record, then you would provide a notice of denial for that information and then provide the record. Does that make sense? Okay. So 309 is confidentiality claims, and this applies to trade secrets and situations where a contractor is providing information that, if it were disclosed, would give some other business a competitive advantage over them. So confidentiality, when you get that kind of information, then that business or company must provide you with a confidentiality claim if it's going to be protected. And that confidentiality claim is a concise statement of the reasons why it needs to be protected. Then if you get a request for that information, then you would need to go back to that business and let them know that there's a request and take it from there. But I think it's important to know that you should collect these or ask for these at the time you get the information, and not wait until there's a request for something that the contractor has provided you and then go back and ask them. Because according to the law, it should be provided at the time. Okay. And I think there's one other section I wanted to mention, and that is 310, which I don't have a slide for, but records are public after 75 years. That's what it says, but actually in more detail it says that classifications are not permanent, and that at the time when that classification is no longer relevant or important, then it doesn't have to be protected or restricted anymore. And then after having said that, it says that all records are presumed to be public after 75 years or after 100 years if the subject of the record was younger than 21. So That's, are there any questions about classification, how to classify records, or what's what? So we'll move on to section 401, which is the appeals process. And in this section, the handouts and material that you've been provided is not a comprehensive analysis of everything the law says about appeals, but we've gone through and selected those things that we think are most important for you to know. So we're, pulling in the information that we think you need to know in order to deal with GRAMA requests. So the first 401(2) says that a notice of appeal shall contain the following information. So I guess that even before we talk about that, any person who disagrees with your notice of denial or your denial of a fee waiver or your claim of extraordinary circumstances can appeal that decision. And they have 30 days in which to appeal. And the first level of appeal is to the chief administrative officer of the governmental entity. So they will do this by sending a notice of appeal to the chief administrative officer. And remember, when you denied the record, you gave them the information about how to appeal. And so their appeal has to have their name, mailing address, and phone number, and an explanation of the relief sought. And they can file a short statement about the facts and reasons and legal authority in support of that appeal. So there's another important element here, and that is that the chief administrative officer has what is called the weighing privilege. So this is talked about in various places throughout GRAMA, but basically it means that the chief administrative officer has the authority to decide that in a specific situation, a record is properly classified as private or protected. However, in this specific instance, the public interest in releasing that record is greater than the interest in restricting access. So as a records officer, you can't make that decision, but the chief administrative officer does have the authority to employ the weighing provision and make that decision. The State Records Committee and the court also have that authority to use the weighing provision to release records that are properly restricted. So there's a lot of details, and there's more information in your packet about different classifications of records and levels of, like, for example, if it's investigative records, then there has to be a preponderance of the requester has to provide a preponderance of evidence that releasing the record is in the public interest before the chief administrative officer could exercise the weighing provision. So there are a lot of details about that I'm not going into, but the next point is number 5. The chief administrative officer's response. We'll see. So the chief administrative officer has 5 days in order to respond. Only 5 business days. But if it's involves a confidentiality claim, then they have 12 days. But so the chief administrative officer's response is similar to your denial. It needs to include identify the records being denied, a citation for each one, and then let the requester know that they have the right to appeal to the State Records Committee or to district court. Or if you are a city that has established your own appeals board, then you would let them know the details of that. So basically, the chief administrative officer, if they decide to persist in denying the records, would have to say what's being denied, the citation, and explain how to appeal. And the time limit for that appeal is also 30 days. So yes.
So they have, if the chief administrative officer denies, they have 30 days to appeal. If they just don't respond, it's considered constructive denial. They have 45 days. Is that from the end of the period in which the chief administrative officer is supposed to have responded? In other words, the end of that 5 days or extended 12 days?
I don't think it's clear on that, is it? So I think, I've thought of it in this way, but I don't know if I'm right.
Obviously, the date the
But
response period expires.
I've thought of it in terms of the date they gave the request. It's 45 days from the time they appealed. But I don't know if that's right. Okay. So new in the law in last year's session is a requirement for the requester to, on the same day they appeal to the State Records Committee or make a judicial appeal, whatever, the same day they appeal, they are to notify you that they are doing that and give you all of the records connected with that appeal so that you're not blindsided and, get notice and not have any idea that they are appealing. So the requester is to submit to the state records, if this is to the Records Committee, a statement of facts, reasons, and legal authority in support of the government. Oh, I'm wrong here. It's the same for both sides. So the requester is going to provide the State Records Committee with a statement, an argument for their position, and then they are to provide that to you as well. But within 5 days before the hearing, the governmental entity is required to provide to the State Records Committee Executive Secretary a written statement of the facts, reasons, and legal authority in support of the governmental entity's position. And so you have to send that to the State Records Committee Executive Secretary earlier than 5 days before a scheduled hearing. Okay, how many of you in this room have ever been involved in a State Records Committee hearing? Quite a few, actually. Okay. I think those are, so the details of the State Records Committee and the hearings are not included in your packet, and not, although it is included in GRAMA. But basically, the State Records Committee is a seven-member body appointed by the governor that hears appeals. And so the requester and the governmental entity will appear before the State Records Committee, and each will make their argument. And then the State Records Committee will deliberate openly and make a decision. And after they make a decision, either to release the records or to uphold the denial, they will issue an order. And then the requester has 30 days after they issue the order to either comply by providing records, if that's what the order is, or to appeal to district court. And if they don't, either party can appeal to district court if they don't agree with the decision of the State Records Committee. But that's basically how it works. And the last thing I want to bring out is section 701, which is further down. But it says that each political subdivision may adopt an ordinance or a policy applicable throughout its jurisdiction relating to information practices, including classification, designation, access, denials, segregation, appeals management, retention, and amendment of records. So that means that you have the authority to more clearly define the provisions in GRAMA for your specific subdivision. And that includes creating your own appeals board and appeals process, or creating your own retention schedule separate from the ones that the state archives has posted. But so those are the parts of GRAMA that we feel are important for you to know to answer GRAMA requests. And that's basically all I have to say.